can get this going for everybody. So we're here for our November update. We figured it was time to do another eviction update. And Brian, interestingly enough, when I went to go put this presentation together, I pulled from the one we did in May. And there have been a few changes, but a lot of the stuff is still the same as it was in May, which I don't know is good news or bad news.
Depends what flavor we're looking for. It's probably a little bit of both.
Might be a little bit of both. So thank you everybody for joining us for our landlord management series. I'm Angela Zykowski, and I'm the director of the Vermont Landlords Association. And with me is Brian Armstrong from KW Realty and Strong Willed Property Management.
And Angela, I can't stress enough in saying so many people are here. You guys do such a good job keeping us warm, advocating for our rights, while also finding balanced ways that we can be better community stewards. And so when I was thinking of today, and I'll be candid, I have a little bit of a short-term memory challenge. But I remember when COVID hit, we saw obviously the system stop, the system grind. I was guessing, unlike a hurricane, we're not seeing C-130s with National Guards flying in judges to catch us up in the system. So I was really looking forward to today because I think we're going to probably see some more challenges as some of the federal subsidies, subside and we get back to, living without that government assistance.
Right.
So with that being said, what are you seeing? What's happening? And how can we better avoid, the pitfalls of common mistakes in this area?
Right. And so I think right out of the gate, what I'm seeing is we're already seeing the impacts of the Vermont Emergency Rental Assistance Program ending, other rental subsidies ending, and so evictions have upticked. And the evictions that have upticked are the non-payment of rent type of evictions. We've also, there is some other more traditional style money available. So prior to COVID, CVOEOs, capstones, NECA, those types of organizations had what were called HOP funds. And HOP funds could be available for 3 months worth of like back rent assistance. They require sort of payment plans if there's more than 3 months owed, and that landlords say, look, we're going to stop an eviction process if you take this money. And there's also some look at affordability. So is this unit affordable for this particular tenant, or are we going to pay this 3 months of rental assistance and then we're just going to be back in this situation again? So those HOP programs have been refunded. So that money is out there and available. And so I think my takeaway from that piece, knowing that those HOP funds are for 3 months, is don't delay sending your notices. Particularly if a tenant is behind on the rent. And I think we'll get into sort of the first slide, and this is related to eviction delays. So I think, assuming I can get it to go here, did it freeze? There we go. I think, my hope is after folks have seen this information and have had a chance to process this, they'll understand the importance of not waiting. And, I think landlords want to work with tenants. They want to have tenants be successful in the apartment. And so many times they'll delay sending a notice because they don't want to create problems or they don't want to cause issues for the tenant. But I think you're not doing yourself any favor, you're not doing the tenant any favor by waiting. So the further they get behind, the harder it is for them to get out of that. So what we're seeing in terms of eviction delays currently is that by far and away, the biggest thing that causes a delay in an eviction is some form of issue with the termination notice. And I think, unfortunately, some of the issues that we're starting to run into with termination notices, they're new. Uh, Tenant advocates and folks representing tenants are getting creative with their arguments to the court. Some are being agreed by the court that they're a basis for a dismissal. Some are not. But it's a really challenging position to be in when the ground underneath your feet is moving. And so the information I'm giving you today is current and accurate as of today. Tomorrow it could actually, later today it could change. Tomorrow it could change. Next month it could change. And so it's very frustrating, I think, for housing providers, for attorneys representing housing providers, because you want some level of predictability. So why is there so much focus placed on this termination notice? Part of it is because the termination notice has been deemed what's called jurisdictional by the court. So what that means is that if you don't have a good termination notice, the court doesn't have any legal authority to hear your case and to have your case go through the system and have the tenant evicted. So that's why there's so much focus on that one particular document. I tend to handle notices from a incredibly conservative standpoint, because it is so important. I would rather have landlords give more notice. Like if it's close, like we think you might fall into category A or you might fall into category B, A is 60 days and B is 90 days. I'm going to advise people to send the 90-day notice, because you don't want to send the 60-day notice and find out you're wrong and then have to restart with a 90-day notice down the road. So it's a very sort of aggravating position to be giving advice to people about, and helping them navigate. But given how important that one piece of paper is to your entire case, just kind of file that away and remember that as you're sending notices out to folks. So that's the big delay that we're seeing with a lot of these cases. The second delay we see is tenants avoiding service when we get to a court case. Depending on which county you're in, some judges require 6 to 10 attempts, some require 3, some are okay with 4 or 5. But the sheriff has to go multiple times to try to serve the person. They have to go at different times of the day, on different days of the week. And so that, again, all takes time to process and to do. Meanwhile, your rent's not getting paid and, tenants disturbing the neighbors maybe, or there are other issues at the property. And then I think what we're all still seeing is some court schedule and some court scheduling issues. We're still in this hybrid system where some court hearings are happening online, virtually, some are happening in person. We have counties where we don't have judges still, and so judges from other counties are trying to cover for those particular civil counties. So maybe there's only one day of civil court a week. And so that's really creating sort of a delay. I think the courts are trying the best they can, and they're doing and trying to schedule things as quickly as they can. But there's only so much time in the day. And when you have one judge that's covering 2 or 3 counties, scheduling can become an issue. So that also is creating just sort of delays.
Angela, do you feel comfortable in discussing which counties are seeing that, the speediest, or this, your opinion is the slowest?
Yeah, I think so what I'm seeing right now, Washington Civil is actually processing cases relatively quickly. They're 100% virtual right now. So the courthouse in Montpelier got completely flooded out in July. They're still flooded. And so everything's in the virtual environment, but they do have full-time judge for civil court. So that county's processing relatively quickly. Chittenden is lagging behind. I mean, there's a full-time judge in Chittenden Civil that has a very full docket, but it's a very full docket. It's probably one of the busiest dockets in the state of Vermont. And so there's a lot of cases that are having to go through that court. So we're seeing some delays. Chittenden used to be one of the fastest. They're sort of in the middle of the pack, I would say, at this point. Rutland's doing a pretty good job. They don't have a judge right now in civil court. So given that they don't have a judge in civil court, I think cases are moving relatively fast for that scenario. And, you know, in like Franklin Grand Isle, we're seeing there's the judge that is in civil court is in both Franklin County and Grand Isle County. So there's sort of sharing across the two courts. Addison County is what we call a multi-jurisdictional court. Same with Lamoille. So the judge sits in civil court, criminal court, and family court. And so in those courts, even prior to COVID, we saw the civil docket sort of is at the bottom of the list in terms of scheduling because so many criminal and family court matters have very strict timelines associated with them that are required for scheduling. So, you know, I think we've just seen a further tightening of some of those issues we saw prior to COVID when it comes to scheduling.
And if I may just interject, what you
Yeah.
said earlier, filing these right away is absolutely essential. And while we've had very low evictions, we did, and this is a personally owned building, did a favor, took a chance with, you know, a son of somebody that we know. And, you know, the one mistake that we made was when they started to have challenge, we didn't file right away. And the person involved did it because, you know, the family were trying to be kind. Whereas my approach is you can always unwind an eviction.
Yes.
It's nearly impossible, save a buyout, if only if agreed to.
Right.
Can you lose that? Can you gain back that lost time?
Right. You can always choose to not pursue a termination notice further. You can choose to not file in court, but you can't file in court unless you have that termination notice out there that has matured.
And you
So
may get to this next one.
yeah.
So just tell me, take a deep breath. I've had a lot of coffee today. Is the 14-day notice, the 30-day notice, federal, Vermont, you know, or federal debt collection?
We're going to get into all this. In fact,
All
let's
right,
start
sounds
with
good.
that
Thank
right
you.
now. So one of the things that we saw happen during COVID, and the folks that have been attending these regularly have been hearing me talk about the CARES Act ad nauseum for a really long time. And so the CARES Act brought some federal restrictions. It brought some federal moratoriums for both evictions and foreclosures. But one thing that the CARES Act did not do was it did not sunset, which means the provision did not go away after a certain period of time of one of the regulations for rental properties. So 95% of the CARES Act is now gone. It is no longer in existence because it had these natural sunset provisions written into the federal legislation. This one particular section did not sunset. And so this is related to how much time a tenant needs to get for a non-payment of rent notice. And this federal statute itself describes this covered property and what a covered property is. And what I can tell you is, as an attorney, I have read these sections, and determining whether a particular property is actually considered a covered property under this federal regulation is incredibly challenging. And I think you would spend more time in court arguing about whether or not you were a covered property than you would just sending the notice and complying with this federal regulation, which is a 30-day notice for non-payment of rent versus Vermont's requirement of 14 days, or if you're a mobile home park owner, 20 days. So my general recommendation is just make your termination notices for non-payment of rent 30 days. Then you don't have to get into the weeds about whether you're a covered property or not. You don't have to get into a giant argument with somebody at court about whether you should have sent a 30-day notice or a 14-day notice. And based on what I've seen with the times for motions being filed and the time it takes the court to process those motions, because it would come as a motion to dismiss. You didn't comply with these federal regulations. You could have sent the 30-day notice. Like, it's going to take longer to deal with the motion to dismiss in court than it would have been if you just had sent the 30-day notice. So I am still recommending that landlords send 30-day non-payment of rent notices. And part of the reason for this is when you file a case with the court now, still in Vermont, they have this declaration of compliance that they require you to file with your non-payment case that says, I've complied with the CARES Act. So they're still looking for that. They're still looking at these. In lots of other states, from what I understand, the courts don't even care. They're totally not ignoring. They're not dealing with motions if, a legal aid in another state tries to file it saying you haven't complied. For whatever reason, our court system here has been all in on this. And so I think we're still sort of stuck with this 30-day regulation until the federal government does something about it. So I think that's where we are right now. And again, right, as I said before, I give very conservative advice when we're talking about a termination notice because of how important it is to your eviction case.
With that too, and I completely agree. If you're thinking it's 30 days on this day, but you depending if it's count the day you start from or not, just do 31, 32, 33.
Do 35 or 36
35.
if you're putting it in the mail.
Yeah, and that's actually, you have any suggestions? Doesn't matter, regular US mail, certified, overnight package, priorities, so you can guarantee evidence of delivery. Any recommendations to better on our pursuit?
I mean, the normal recommendation is certified mail, first class mail. Those have become somewhat unreliable. We know tenants don't sign for the certified mail. I'm starting to consider shifting to sending notices via priority mail. Priority mail, it's like 2-day delivery for most of Vermont. It comes with tracking. It comes with delivery confirmation. Tenant doesn't have to sign for the notice, but you have proof that it was delivered. The green card, if it actually gets signed, then you have further proof that somebody actually received it. You can hand deliver notices. You can't, email's not considered valid delivery in Vermont. And actually don't know what a court would do if you had an email delivery and then the tenant signed like a receipt for it. Like who knows? I think if given the opportunity, failing to strictly comply with the statute on delivery, I think is an easy out for the court to just say, nope, you didn't comply. And so the statute says actual notice is receipt of the notice that's either been hand delivered or mailed to the tenant. So, and you can also have the sheriff serve the notice as well. So, so that's where we're at with the CARES Act. So you're going to hear a lot about some federal things that are happening because we have a new player that's entered the field here since we did the seminar in May. So we have the Federal Violence Against Women Act. And really, what does this have to do with termination notices? Well, I'm going to give you the nitty-gritty details on that. And I think we have something popped into the Q&A. So I don't know if that was pertinent to the CARES Act information that we were going over or not.
We just throw the book and do certified mailing, regular first class.
Yeah. Yeah.
I used to do everything from email to drop off to physical. And part of it was make sure they got it. Part of it was to also remind them on multiple fronts,
Right.
we're determined.
Right. Exactly. And I think you can't send it too many ways when you have to prove that they got a copy of it. So
Mhm.
it seems redundant. It seems really wasteful. But that's where we are. And so I'm going to give some more bad news to you about increased postage cost and additional things. So in October of 2022, Congress reauthorized this federal statute. So it had expired for a number of years, but it was reauthorized in 2022. And so, Angela, what the heck does this have to do with termination notices? So in this federal statute, there's a provision that requires you send a copy of some VAWA notification. So there's two different HUD forms that be included and sent to any notice that you're sending to a tenant. And this is specific to subsidized tenants. So this doesn't apply to sort of your standard market rentals. But if your tenant has any sort of subsidy, whether it be Section 8 or some other form of rent subsidy, I would advise including these forms in with your termination notice. So what has happened is there's been a series of motions to dismiss in the courts that have gotten us to the point where if you do not include these forms with your termination notice for these subsidized tenants, that the courts have been dismissing cases when this issue has been raised. And so they follow the same logic that was used with a copy of that notice also needs to be sent to the housing authority at the time you're sending it to the tenant. So the courts are using the same logic that you haven't complied with the statute, you haven't done all of the notifications that you need to all of the people that need to get those notifications, and therefore your notice is not good because you haven't done all the things you need to. I will tell you that the VAWA notification, so the HUD form 5380 is about 8 pages long. The certification form, the 5382 is a couple of pages long. And so, this is drastically increasing the amount of paper that you now have to include in with some of these termination notices. And it's for any notice. So it's for non-payment of rent, a no-cause notice, a breach of lease notice. So any form of termination notice you're sending to those subsidized tenants needs to have these two forms included.
And that's any subsidized tenant, whether or not we think or have any information that it necessarily applies.
Correct. Correct. Any
I've grown
subsidized
again
tenant.
today. Thank you very much. I
Yeah.
don't know if I love where I'm growing, but
No,
thank you
I
very
know.
much. Yeah.
So this is really new. Like this has just been developing over the last couple 2 or 3 months. Really saw a lot of activity in like June and July. But I think, this is where we are now with this one. So if you need those forms, the Landlords Association has them up in the forms library. You can also Google, HUD form 5380. It will come up. HUD has them out and available for folks to download. So that's yes. If my one takeaway is make sure you're complying with these various requirements because it gets you into that delay number one, which is these are easy things for the court to decide on and dismiss a case over at this point.
Which goes again to what's our screening process? How thorough are we? And I hate to say it, operating somewhat like a machine. The moment somebody hits the mark, it can be issued. Make sure that we issue all the forms, so that we can do our part to work with those who are willing to stay current.
Yeah, I mean, I have some landlords that they have like a day of the month, whether it's the 10th of the month or the 15th of the month, and any tenant who owes any money is getting a termination notice for non-payment of rent. They're even sending them to folks that are in with payment plans. They've been sort of very clear with them. Look, we're going to continue to send you a termination notice. If you're paying as agreed, we're not going to do anything. But we have to be prepared, and we can't be waiting to take this action because we have such a delay from when we can even file the case for unpaid rent. So, I mean, think about that. If a tenant doesn't pay, say, December 1st, and even if you send that notice December 5th, when you're talking a 30-day notice, you're already into January. So before you even are able to think about being at a point where you could file with a court, you're already 2 months potentially behind on rent. So, I don't know what the right answer, like, is this a better system that, we're going to push people to take action quicker? Is this, a situation where it's just creating more chaos for folks? I tend to think it's creating more chaos for folks than, having a system where people feel like they can have a little bit of time to have these conversations with tenants about the rent situation. So
The perspective I have is making us think again more like machines, because
right.
we can't have the conversations. We just have to X, and operate. And while probably 89% of the people who walk this earth are well-intended, honest, decent people, what I've often said to our kind residents who I know are well-intended, I meet a lot of individuals who intentions are not in line with their capabilities.
Yeah. Yeah. And so I think, like this next slide that we have coming up is, I touched on this a little bit at the beginning, why are these termination notices so important? Like, why we spend so much time and so many seminars on this one piece of paper. And again, it's this notion that the notice is jurisdictional. So without proper notice, the court says it doesn't have authority to hear your eviction case, doesn't have the legal authority to process the case. And so if your notice doesn't comply with all of these various rules, and these are very technical rules, and they are, attorneys are trying to navigate this as well. This isn't something where you're like, oh my gosh, I'm just a landlord, how am I going to know all of this stuff? This is become sort of a minefield even for attorneys, because there's, what's new, what's coming down the pipeline, what's the next thing, what's the next little weird thing that we're now going to have to adjust for. And I don't necessarily see a way out of it. I don't even know that we could legislate our way out of this at this point, because some of these are federal things that are overlaying, and every time we've tried to correct something in the notice section of the statute, we just have created a new space for people to make new arguments about how notices are bad. So, I'm not entirely sure what the answer is. I'm totally open to creative solutions or creative thoughts that folks have for what's a way to fix this. For me right now, it's just get that notice out fast, comply with these requirements. Yes, it's not very much fun. Yes, it's a lot of paper, but let's just, deal with it, because we got to do this to get the tenant out in the end, or get them to pay. And this is my final one. So reading the statute. So we talk about this landlord tenant statute that we have here in Vermont isn't going to give you all the information. As you can see, the 2 prior slides we had were all related to federal regulations, and little tiny buried regulations that are like a 1-line thing in pages and pages and pages of federal rules. So, it's, don't feel bad if you're thinking, oh gosh, I sent out notices and I haven't done one of these things, or I didn't know that. You're here, you're learning it. That's now, and this area of the law has been changing. I mean, we saw a ton of rapid changes through COVID. We've continued to see changes. And, the way things were 2 months ago isn't necessarily how they are now. And so again, that's a really hard place to plan from, really hard place to, ensure that you're doing everything correctly, because information's changing fast. Brian, I thought you had all kinds of questions. I'm waiting.
Well, one is I'm getting blown away by the complexity, and I'm thinking just how important it is to one, work with the Vermont Landlords Association, and two is to just really become systematized, which sounds cold, but I think it's becoming essential.
Yeah.
And so I'm going to guess, because one of my questions was, what are the most common mistakes? And I'm going to guess you've already answered that, is they don't file, very quickly. They don't include federal forms, and probably in their eagerness to possess their units, don't play the timeline game wrong.
Yeah. And I mean, and I've seen, everything from the landlord didn't list out the address in the termination notice, or didn't list out the full address. So, the notice might say your tenancy at 123 Main Street is terminated. Well, but there's no city and state in there. Like, it's, that's how precise these notices have to be. Or the date of the notice itself hasn't been dated. So there's no date on the notice to show like this is when this notice was sent. Like some of them are really minor sort of details, but they're things that, again, if you're systemizing your process, and you have a routine and you put the same information in every time, you shouldn't have any problems unless, something changes under the rules. So, one of the things that we go back to is this is one of the sections of the statute that we can actually read and understand what's required because this particular term, actual notice, which is required under the statute, is defined. It's one of the few terms that's actually defined. So what this means is that you have to prove the tenant received the notice, but they have to have received it via mail or hand delivery. So the statute is that specific in this circumstance. And again, we've talked about this, but again, I think it's worth repeating because this one document is so important. So you can send it certified mail, return receipt requested. I would not do certified mail just by itself. Probably 90% of the certified mail that I send out of my office is returned as unclaimed. Tenants just generally don't sign for those. So I usually do it in tandem with a regular first class mail. So both of those go out at the same time. And there is what's called a delivery presumption in the statute. So the statute actually says receipt is presumed 3 days after it is sent. That presumption is what we call is rebuttable, which means a tenant could come back and say, oh, well, I didn't get it. I had problems with my mail. That's what we're hearing a lot. I've had problems with my mail. And I think we all know we have all had problems with our mail being delivered in a timely fashion, being delivered at all, going a week without any mail, and then you get 2 weeks worth of mail at once. So if you're mailing, I would suggest you add a bunch of extra days into your notice. I think I said 5 earlier.
Yep.
I'd almost say 10 because we have seen some very weird things happening with the mail. And again, thinking back to how important this one document is.
So, Angela, we've talked about state notice, different federal notices, and then you mentioned hand delivery. Does it take I take it this what we discussed, priority certified meets, all three, or at least the two, state and federal. Now,
yes. So the certified regular mail and priority would comply with the mailed section of the statute, right?
What about hand delivered?
So hand delivery, yeah.
I got my phone video recording,
Mm-hmm.
and I say, Mr. and Mrs. Smith, just want to say thank you very much. Here's your notice. I've got them on video, accepting it. That good, that bad, that,
Yep. That's hand delivery. I think, it's even better if they'll sign your copy stating they've received the notice. They won't always do that. But some sort, video recording works, taking another person with you. So there's two of you. So if you have to testify to that. What hand delivery probably is not is putting a copy in the door
Yeah.
or taping a copy to the door, though maybe. So I'm going to fast forward here to this bottom point that's related to whether or not a sheriff, and so this is just at the notice phase. This is not under what's called attack order if we're in court. This is just the termination notice. The sheriff taped the termination notice to the door because the tenant wasn't answering or wouldn't come to the door. So the sheriff was there. Tenant acknowledged at court that they received that copy. They had pictures of it. It was clearly the notice that was taped to the door by the sheriff. But the tenant was arguing that it didn't comply with the statute because that wasn't hand delivery.
How the judge rule?
So it said waiting on decision, because when I put the slide together, I had not seen the decision. And so I have since seen the decision, and the court punted and did not answer that question because the tenant had actually vacated. So when the trial happened, the judge went the direction of, well, this is just a hearing for damages. It's not an action for possession. So we don't need to decide on this issue about the delivery of the notice.
Interesting.
So we still don't know whether attack to a door like that with an acknowledgement by the tenant that they actually did get a copy of that notice is compliance with a statute. Oh. So
help me understand a little bit.
Throwing that out there for the universe to digest.
Studying a little bit more of your world on this.
Yeah.
As far as if a Chittenden County judge were to say that meets mustard, does that affect the rest of the state? That is setting precedent? Or is it like I'm used to dealing with on property management side or the real estate side? We could get a fire marshal from one area of the state that has a different opinion of what the interpretation of the code in a different area of the state and get two different opinions from two state officials on the same topic.
Yep. You can get different opinions from different trial court judges around the state. What we've seen happen is because now we're in this sort of electronic filing system with the courts, it's much easier for legal aid, for my office, for lawyers to collect trial court decisions and provide them with motions to dismiss in other counties. So we're seeing a lot more consistency, perhaps. So if it starts in one county, we're seeing much more often that when that same issue is raised in other counties, because you can attach those other decisions now, that the other judges are following suit, where before it was sort of a hop, who knew, it was all over the place. So it technically is, the judge in a trial court level could make their own independent decision and say, no, I don't agree with this. I'm going to find in a different way. We don't see that happening. But they do have the ability to do that.
Thank you.
Yeah. And I would just stress again, email delivery of a termination notice is not authorized under the statute. So the statute itself has not caught up with how people communicate today. So it's not email, it's not text message, it's not messenger, because I guess some folks are communicating on Messenger and other social media platforms, which is maybe a different seminar about why that may or may not be a good idea. So we're still sort of old school with personal service. So handing it to them in their hand or sending it through the mail.
This has been very, very thorough, Angela. Thank you very much. The fact I haven't asked a ton of questions is a compliment to the thoroughness with it. And I'm definitely grown quite a bit today. So I'm going to be checking our models and systems and protocols and making sure, as I'm sure
Yeah,
Dan is, he's up to wear on everything. But particular, the VAWA, if I think I had this,
yeah.
yeah, correctly, that's going to be definitely an interesting one. And as a side note, and this may be entirely off, well, not entirely off topic, but what is your opinion of the volume? I mean, you're one of the first people that I think of when we have tenant issues, to assist with. What is your personal opinion of the number of attorneys handling evictions? I've heard some people say that we're seeing an exodus, which is going to potentially, potentially create more hardship. And as a side note, I hope your kids grow up to be attorneys for the Vermont Landlord Associations.
They probably won't. As a side note, um, I it it's a mixed bag. I mean, I think we've seen some new entry into the landlord housing provider representation field. We've also seen some exodus of attorneys who, between all of the COVID requirements, the online court hearing model, just were like, don't want to navigate this any longer. So I think, I think it's been relatively stable between the attorneys leaving the field and sort of newer attorneys. And when I say newer attorneys, I don't mean that they're like fresh out of law school kind of attorneys. They're attorneys who are experienced, who maybe are shifting focus of their practice. But we've seen a great uptick in the number of cases. And so, with everything being equal, there still feels like there's a shortage because there's been such an increase in the number of cases being filed for evictions. And again, mostly they're related to rent and rent issues, which might be an entirely different seminar on why, on sort of that issue. That's a whole different issue
Because yeah, we're
related to,
seeing
yeah,
rents climb, and although I thought I might have heard in some cases they might have gone down federally in some areas, we continue to see in our portfolio and our clients' portfolios significant rent increases. Which is just driving the challenge of
right,
affordability, which is going to show up. I think both the foreclosures are on the rise, not dramatically because
right,
people can sell their homes or properties with equity, based
right,
upon the appreciation, but certainly with affordability.
right. And I think, the rise that we've seen is related to increased in operating costs. I think um, we're seeing it in increased costs if you have an eviction. So between, given the amount of time that it's taking for an eviction, that's lost rent. I've seen a significant uptick in the amount of damage that's been done to a unit by the time the tenant exits the unit, um, at a level that is sticking with me, compared to what I had seen previously in my career. I mean, I've been doing this for 20 years. And that used to be a very rare occurrence where we would see a high level of damage to a unit on the tenant's exit. Um, I'm seeing more and more highly damaged units at the end of an eviction now. And that comes with a cost to the landlord, to future tenants,
Yeah.
to what the rent is for that particular unit, whether that unit even comes back online or not. And I think, that's one of those missing components here as we're talking about housing and the cost of housing. There seems to be a disconnect and an inability to marry those things together, because, landlords aren't raising rents just to raise rents because they think they can make a ton of money. Are
Absolutely.
some landlords doing that? Maybe, I don't know. I feel like they'll find the one that did that, and say, all landlords have done this. Most landlords are raising rent to try to keep pace with their expenses and their
You know,
ability to maintain those properties.
Absolutely. And maybe this is slightly off topic, but related at the same time. You know, which, and not that collecting more deposits is going to be helpful, but is it, is my memory, correct in that Burlington and Barry, and I thought maybe Rutland were prohibiting anything more than first month's rent,
Yeah.
and the security deposit. because I think in other municipalities, if you could update on this, you can do first, last, and a security
Right.
deposit.
Right.
You,
Just Burlington and I believe Brattleboro now at this point has Barry did away with theirs. So they
interesting.
used to have that restriction and they rolled it back. So
That
just
may
a
be something we have to consider as landlords and balance serving our community, providing housing, building our families, wealth, and protecting what is, it sounds like a lengthening trend
yep.
in a couple different directions.
Absolutely. So I wanted to put some reminders out there for folks. We've talked about these before. If you are not the person that owns the building and you're sending termination notices, there is debt collection language that you need to include in those termination notices. Because you're considered a debt collector, particularly if it's a non-payment of rent notice. So anything where the notice has money and money things in it, you absolutely need to make sure you have that debt collection language in it. Just another reminder about if the tenant is receiving some form of subsidy, that you need to send a copy of that notice to the housing authority. That's the entity, Vermont State Housing Authority, Burlington Housing Authority, Montpelier Housing Authority, that's paying you a portion of the rent. And you need to send that copy at the same time you're sending it to the tenant. And now you also know that you need to include all of these VAWA documents in with that copy of the notice. And I think, side note, Burlington Housing Authority had been taking the position that when they received a copy of a termination notice, they were sending the VAWA documents to the tenant for the landlord. That actually got challenged in court, and the court said, nope, statute says landlord or whoever's sending that notice to the tenant, you have to include it in with the notice. So,
Interesting.
yeah. I feel like this one is super obvious, but I've seen it enough that I have to say it when I do these seminars. Please keep a photocopy of the actual exact notice that you have provided to the tenant. Don't just be like, oh, well, I have it in Word and I'm just going to print it off if I need it for an eviction. The copy, whatever you have put in the mail to that tenant, make a photocopy of it, take a scanned copy of it, keep an exact copy of that termination notice. You are going to need it if you go to court.
Anything comes to mind when you're evicting with somebody with co-signers?
Also a good idea to copy them on a notice if you're sending it, particularly if it's related to a rent issue or a financial issue of some sort. It's not required that you provide them with a copy of the notice, but it's a good idea because if somebody's going to pay, it's probably going to be a co-signer.
Yeah, it's not going to affect the process if we don't or anything. If they were just dealing with the occupants itself.
Right.
Got it.
So yeah. And I think, let me see, did I talk about it a little bit later? I want to double. The other thing to keep in mind, I think I hit on it later, but I don't know that we're going to get through all the slides. And some of them are repeats from seminars we've done previously, is your termination notice is good for 60 days from the termination date. So what that means is you need to file your case with the court within 60 days of whatever that termination date is in the notice. So it has an expiration date, and shouldn't something, if tenant hasn't paid or hasn't moved or hasn't come to some arrangement with you, I would say by like day 40, they're probably not going to. So don't skate it to like day 59 and then be like, I need to file this case immediately. Like, just,
We can file with the court just by walking in, correct? Obviously, we're better to go through a competent professional such as yourself.
Yeah, because you need some other papers, and the forms are available. You can get them from the Vermont Judiciary website, like what you need, the complaint form, and there's some other things that need to get attached to the complaint now. So also the filing process has become a lot more complicated. And there's things now that you have to do that if you don't can get your case dismissed even once you filed it. So it's all becoming very complicated. All right, so we'll go into a couple of these because some of these have really good, just basic information. So there's 4 types of notices in the state of Vermont now. Non-payment of rent, breach of lease, no cause. No cause is still a notice you can use. Burlington's trying to do away with it. Essex trying to do away with it. Winooski's trying to do away with it. They haven't got there yet. You can still use a no cause notice in all of those jurisdictions.
And if I may,
yeah.
Anybody and everybody on this webinar should reach out to their local representative and ensure that our state senate and house do not support those efforts, because if I remember correctly, we beat the governor's override succeeded by only 1 vote, was it?
1 or 2. Yeah.
I don't know about you guys, based upon what I'm hearing today, that doesn't make me feel super lucky.
No. No. And so I also threw in here sale of building. So there is a special sale of building notice that one could use. And I'm particularly, this is addressed to the realtors who are on this webinar, who are helping folks navigate. You can only use that sale of building notice if there is no written rental agreement between the landlord and tenant. So is not available to you if there is a written lease agreement between the landlord and tenant. So
and on that, so that note too, although if it's in my lease that says Angela agrees to vacate if I place the building up for sale, that wouldn't negate this, would it?
So I think you would still be looking, you would have to use like the no cause notice. Like it's not going to put you within that sale of building. Sale of building section of the statute is very specific. In the absence of a written rental agreement, landlord, upon receipt of a signed purchase and sale agreement, may send tenant a 30-day sale of building notice. Like it is that specific. So yeah.
So we had a question, and Yana, great to have you on. I hope all's going well. And if this doesn't answer your question, please restate. I'm assuming when you request the types of notices, we're talking just about it's on the screen: non-payment of rent, breach of lease, no cause, sale of building. If you're talking about any other forms of notices that we spoke earlier, please correct us in the chat so we can make sure to answer your question and bring value to your time.
So yeah, so termination notices in a residential setting, these are the only 4 that are available to landlord. So this covers pretty much anything that you would need to ask somebody to leave over.
One more comment to the realtors on this. We have the Realtor Political Action Committee, and roughly 70% of the dollars stay within Vermont. I would seriously consider, while it's not to my knowledge a cost you can write off, I would seriously consider a regular donation to that on an annual business, because 70% of the dollars stay in Vermont. And VAR, if I remember correctly, put $30,000 fighting no cause, when it first went through Burlington.
Yeah. They were involved. Yes. All right. So a few more things to notice. See, like I do all-day seminars, or at least half-day seminars for lawyers on just termination notices. So if this feels really overwhelming and really just like, oh my gosh, this is so much information, I do these trainings for lawyers, and so you're not alone. This is super complicated, and there's a lot of moving pieces and a lot of things you have to think about. So one of those is anybody who's 18 years or older who's living in the rental unit should be named on the termination notice. For some reason, I was seeing a string of notices where there was only just a head of household listed on the termination notice. There were other adults living there and they were not named in the notice. And I was like, no, you gotta resend this. Like you gotta have everybody, you gotta terminate everybody's tenancy in the notice, not just one person. So just, make sure that all adults are named on the notice, particularly if they're tenants. Make sure it contains the the address, including the city and state. Like you want to have a complete address in there. Has a specific termination date. And I know this is the one that when I do this training for lawyers, they want to argue with me about it. But it needs to be an actual date. So like September 29th, 2023, not 30 days after you receive this notice. Like that's just, don't do it. It's not a good notice. If you bring it to me, I'm going to tell you to resend it. It's got to have that specific date in it for that termination notice. Da, 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 da. So this is the point where if we were in person, I would make a joke about who's putting their buildings up for sale tomorrow. But
well, as a side note, we should mention that you and I are seriously thinking about looking at it, doing this in person again.
yes,
And I don't know about you, but I'm thinking maybe start off the year in January. So not only we can, whether it's lunch and if anybody has any preference in the chat, continue virtual during the day, in person, maybe get some, light lunch, stuff like that, or even evening, where we can do a little bit of networking amongst professionals. I personally would welcome that.
Yep.
And, with humor, certainly if anybody's thinking of selling, we'd love to talk with you. On the flip side, I remain more confident than ever, despite these challenges, that real estate is one of, if not the best place to do your investments. Because with humor, they're not making any more dirt.
Right.
And for better or for worse, I love our picturesque state, but Act 250 is part of the problem here. And until they address that, we will have it's an opportunity to both solve problems in a community and reasonably build wealth for your family.
Yes, exactly. And so I think I'm gonna cut short. I have like 4 more slides, but we do not have enough time to get through them. So in the interest of doing the stop and start, we, maybe we'll pick up, we can do a part 2 in January, talking specifically about termination notices and the type of termination notices and what needs to go into each notice, because that's also gotten incredibly complicated as well. So I think I'm going to stop our screen share here so we can come back because we've got just a few more minutes. But I think for sure, Brian and I are looking to bring these in person, and maybe we kind of will do a mix of in person and on Zoom. I mean, the advantage to Zoom is that we can record these. It's much easier to get them posted so others can watch. We should be able to sort out how that could work for maybe a hybrid in person slash.
Some great technology. It's an owl. It's not perfect, but it's got 2 or 3 cameras on it. And so the challenge I find with hybrid is we just gonna have somebody really moderating the chat so that it's inclusive. But with humor, we've got one that suggests more, training opportunities online, and another great one. Renee, great to have you on here. In person would be great. So I think maybe potentially mixing it up might be a great way to do it.
Yeah, folks, so I mean, Brian and I have been doing these seminars for about 2 years now. We started 2021, maybe even late in 2020, and we have recorded all of them. So they all live on the Vermont Landlords Association YouTube channel. So you can go back. There is a huge number of historical ones. Some have definitely stale information at this point because it's related to COVID stuff and what was happening at the time, but they're interspersed in those are a lot of really good meaty seminars that Brian and I have hosted for the landlord and property management community.
On that note, too, if anybody's got any last questions before we wrap up today, we would love them because we really appreciate you guys showing up. And Angela, can't stress enough, thank you for all that you're doing for property owners' rights, and so forth. The other thing that comes to mind, too, is it may be worthwhile for us to potentially have some people in addition to other things, talk a little bit about either 1031s or cost segregations, which may have less to do with running rental properties, but it may have more to do with helping, your members and our clients and everybody here look for other tax advantages that will further their ability to both solve problems and, retain wealth in a very interesting and ever-changing environment as the last couple of years have changed. Now with humor, I'll remind everybody, Nostradamus said there's going to be a massive fire in the beginning of this century. Check. Pandemic. Check. then mass captivity, which I'm guessing is quarantining, then the longest period of recorded peace the world's ever known. So hopefully this is just part of that before that new chapter begins.
That would be great. I will say thank you to everybody for joining us today. I think are planning one more in December, and then I think we're back to do an in-person one in January, and then we'll see how February goes. February may be online. So, if you don't follow the Eventbrite page for this seminar series, I would recommend it. That's where you're going to get first notifications when a new seminar is posted.
Excellent. Folks, thank you very much for attending. Angela, can't stress enough. Thank you for all that you and the association are doing. I look forward to the next conversation, the next session. Again, I'm Brian Armstrong with KW Vermont and Strong Will Property Management. Have a great day, everyone.
Angela Zygowski from the Landlords Association. Thank you for attending today.